here because tomorrow we file 2 civil rights lawsuits in Cincinnati. That happens tomorrow. And I was wondering why that was a little low. How's everybody doing? Good to see everybody. How you guys doing? Where's everybody at? Where are you from? Type down right there where you guys are watching from, if you would, please, just so I know, kind of have an idea of who's in the room. I'm going to tell you guys some stuff. I'm going to introduce you to somebody on here that maybe I've never introduced before. Let me make sure. Yep. Okay. What's up? He runs a dungeon for sure. I'm going to introduce you guys to someone today on the live. And so do me a favor and don't, good to see everybody. How's everybody doing? Where you at? Hit the #1 button if you're great. And so just hit the #1 button and just, we get through this. Because what I'm going to express right now, X Factor. So I work with people all around the country. I'm not very, X Factor will tell you, I have a lot of people who do a lot of great things working with me, and I'm so grateful to those people around the world right now. There's 2 people who are working on things. I just attached a 3rd person to the same task in this investigation. And so now I have 3 extraordinarily talented, smart people who are investigating things that informants have told me. And then the voicemails that I'm getting from people are being sent off to other people to always make sure that we can have pure transparency and nobody would print something that wasn't on the up and up, You just want to print exactly what is the truth. And so X Factor, guys, so one of the people who I work with who is a phenomenal legal mind, who is a constitutional case precedent guru, is in the room now. And I'm going to introduce him. His name is X Factor. X Factor is one of the moderators in here. He has a wrench, but that's not what he does. He actually writes, matter of fact, he just helped me write the appeal for the Tempe court. If you guys haven't seen that video, the Tempe stop, then that's what we're appealing now, because they convicted me based on no evidence. The cops submitted no evidence. There was no evidence for the state, but yet they convicted me. So X Factor, everybody say hello to X Factor Law. Please do me a favor, don't blow him up. I need him to continue to do the work that we're doing. So I'm going to explain something now, and X Factor this is right up his alley. Quick shout out to my buddy David Condon. David Condon in Los Angeles, California. David Condon, what's up, my brother? How are you? Love David Condon. He's a super valuable asset to me. Appreciate you, David. Love you, buddy. Just letting you know I'm here, even though we haven't got to talk. And just so not just David knows, but all of my friends know, I have not been able to talk or associate. I have one of my best friends lives here in Houston, and I've got to see him for like 10 minutes, and then he sees, there's printers and papers, and tomorrow 2 federal lawsuits are being filed in Cincinnati. We served the Lawrence County Sheriff's Department today on behalf of Kent Freeman. The Ironton auditor should have that video up. We served a demand for return of property to the Lawrence County Sheriff's Department, which I can't wait for Ironton auditor to get that posted. So I'm waiting on you, Terry. No pressure. So then tomorrow we will file in Cincinnati in federal district court. I'll be suing Ironton, the Lawrence County Sheriff's Department. Should I make it a surprise? I think I'm going to make the 3rd party a surprise. You guys are going to be shocked. So I'm not going to say anything yet. I'm actually going to keep it to myself. So now, let me tell you what we're seeing in Ironton and what we're seeing in Lawrence County. Because as you know, the people who are doing research for me, what we're seeing is that if you don't pay a fine or a fee, or you don't pay your child support, for example, then they'll suspend your driver's license, right? And if you ever get on a phone call with X Factor, he will go on and on about the constitutionality that you don't have to have a license to drive in America because you're not being contracted labor. You're not making money. You're not making money. You're not a X Factor. Give me a couple words here so that I know what the exact verbiage to say, because I'm a man traveling. I'm not driving. They don't have jurisdiction over me. So now all the things that have come to culmination in my mind from working with guys like X Factor and Bob, and they now figured out a way to manipulate that you have to have a driver's license to drive, with a way to criminalize you. And what do they care the most about is money. They care the most about money. So they criminalize you so that if you don't pay a fine or a fee, then you lose your driver's license. And then, as we all talked about the Ironton audit, the auction, how there's so many things auctioned off, bikes, cars, everything, besides them just stealing them right in front of your house or out of your driveway. That's if you lose your driver's license, then you have to bond out of jail. You need a bond, unless you have $1,500 cash. And so, additionally, then you're in the criminal justice system now, because say you got a fee for shoplifting or for, and I'm going to get into the 5 charges in a minute, but say you have, I don't know, think of any, say you jaywalked, you crossed the street and it wasn't on a green light and you got a ticket for that. It's a $100 fine, but number one, I absolutely protest to paying the $100 fine because there was nobody around and I crossed the street, and why do I have to pay attention to some, there's nobody here. So I'm never going to pay this. As a matter of principle. It's ridiculous. This is an unreasonable fee and fine. But now what I have to do is now turn and face the court with my time, because some moron who doesn't understand why they're even in their position gave me a ticket for crossing a street. So I get a $100 fine. I say I refuse to pay it. And then when I don't pay the fine, then I lose my driver's license. And then you go to jail. And what do you hear me say when I talk to people? Oh, no. You're skipping some steps. You don't pay the fine, you get pulled over. What happens next? You have to get out of the car. What happens next? Put your hands on the car and bend over. What happens next? You're going to have fingers and hands go, they're going to grab every part of your body. What happens next? Torture cuffs. What happens next? Squeeze into a tiny little area. Torture. What happens next? Turn around, squat, cough. What'd you do? You walked in the street. The light wasn't green. Nobody around, but you got a ticket from that guy and you didn't pay it. You don't want to deal with the court because it's ridiculous. This is ridiculous. And in your mind, you think to yourself, I'm not going to have to show my backside to a perfect stranger just because I didn't cross the street here on a green. I didn't slow anybody down, but this guy said I'm bad. The state's out to fine me and fee me for no good reason. So, then what happens though, when you lose your driver's license, is now your car gets impounded. And now, as we've seen in Ironton, a lot of cars are being sold when you can't get their car out of auction because you had to bond out of jail. After you turn around, squat, and cough, they took the torture cuffs off. Then you got subjected to an absolute piss-stained, disgusting crevice of a building. It's the worst thing you've ever seen. Steel toilets. You'll poop in front of everybody. The food is atrocious. You're treated like a beast. There's no eye contact, so you're dehumanized. You don't matter. I didn't look into your eyes and see that you're a human, that you have a soul. And so you did this, and this is the losing your driver's license is the beginning of your continual fees into the government agencies. Continual fees. The ankle monitor business. How many people have paid in to the ankle monitor business? There's so much money in it. Who's making all the money off the ankle monitor business? It's a business. And the ankle monitor itself is torture. It's torture. If you are being hurt by your ankle monitor, you go to the doctor. And when you go to the doctor, you film it. You tell the doctor, this is torture, this is horrible, look at my leg, this hurts. You film it. Doctor has an obligation to care for you. Just like the state, your quality of life matters. Okay. When I'm governor of Ohio, that's going to change. We're going to end that. You don't lose your driver's license. That's preposterous. You don't lose your driver's license. What, an X factor, and this throws an X factor here, I don't know how hard it would be to change the legislation through legislation where you don't have to get a driver's license, but maybe there can be some people that can have a rational conversation about the proper verbiage in the legislation where we could actually take on something where you don't have to be approved to drive, and it's more based on the idea that you can't drive rationally on the street. Because what we're seeing is that an exorbitant amount of money is being taken from the people, the sovereign, we are the power. Jean-Jacques Rousseau, Social Contract, says that we are the power. You and I are the power of this country. And we do that through peace and legislation. That's how we get things accomplished. You don't get anything accomplished with violence and being irrational. You have to follow the rule of law. That's why we're suing tomorrow. Pam, why didn't you just give my phone back, you moron? You thought I was joking. Okay. So, who's lost their driver's license because of, and then I said we're going to talk about the big 5 crimes, okay? The big 5 crimes that is all through the tri-state area where they'll impound your car, right? If you have drugs, you're trafficking. You're definitely trafficking drugs. If you have drugs and you're around drugs, you're trafficking. And you may be used to be a narc, okay? You're tampering. You're tampering with whatever they say you're tampering with, and that is totally subjective to the cop who said you tampered. Okay? You tried to assault a police officer, or you're charged with assaulting a police officer. How many people assault a police officer? How many people want to fight a cop? I'm tougher than half of them, and I don't want to fight them. It's not rule of law. You see? If they're going to act in their official capacity. You tried to run from a police officer. Or you obstructed justice in some way, which is a felony. Those are 5 felonies. That we're seeing over and over and over and over and over. And by the way, then what happens if you don't pay the fees? You lose your driver's license. And then you go to jail and your car gets taken. Now you got to pay to get the car out. You got to bond out of jail yourself. And there's going to be more of the court that you're going to have to pay for. You'll pay for that. You'll pay for that. So now I'm going to show you guys something that, so make sure that everybody knows that, make that I want to hear from you guys if that's what's happening to you. And now I'm going to show you guys something. I'm going to show you guys something that's super inspirational. That is the most inspirational thing I've seen all week. And you're going to love this. I hope you do. Anyway, if you guys want to know more about the driver's license thing, make sure you hit up X Factor Law. I'm going to lower this down. so you guys can see something. I'm going to teach you guys something today. You're going to learn some Supreme Court stuff. Okay? So I'm going to turn this around right here. Okay, and I'm going to turn my camera around. Sorry about that. And we're gonna learn some Supreme Court stuff. So there was a holding that happened. There was a holding, and sorry about that. Let me pull it up here. It's going to be Larry Thompson versus Paige Clark, et al. This means every other person. So ours, of course, says Pam Wagner, and then everybody else. And then the other one for Kent says Jonathan Spuljarek, et al. And then the one for the one Spuljarek raped when she was in high school, it'll say Jonathan Spuljarek versus Jane Doe, because she's going to remain anonymous. Okay? So now here's what you're going to do. I'm going to listen. I'm going to see. Here's how I learn, and I'm going to help you guys learn. I listen.
We'll hear argument next in case 2659, Thompson against Clark. Mr. Ali?
Thank you, Mr. Chief Justice, and may it please the court. The Second Circuit holds that a criminal proceeding terminates in the accused's favor only if it affirmatively indicated that the accused is innocent. That is wrong. A criminal proceeding terminates in the accused's favor when it ends and the prosecution has failed to obtain a conviction.
Right.
As this court has recognized, Section 1983's favorable termination rule protects against parallel proceedings, inconsistent judgments, and collateral attack. That explains why the plaintiff in Heck had to go off and get his conviction overturned on direct appeal, habeas, or through a pardon, and it explains why the plaintiff in McDonough satisfied the rule upon his acquittal.
He's stating case precedent there.
It also explains why the dismissal of charges terminates the proceeding in the accused's favor. When charges have been dismissed.
So, okay. So when you heard him say McDonough and you heard him say the other case, what that is that's case precedent. All laws in America are based on cases previously. So if you go back through the history of time, just go back 1,000 years, were we more or less brutal? We were more brutal. Man was more brutal. You still had human sacrifices. I mean, even in the second millennial, you had Spanish conquistadors and Aztecs who did, live sacrifices. So now as you move forward in time, when you get to the 1600s, remember, it's extraordinarily violent. And then you get to the 1700s, it's getting less, 1800s. But then if all case precedent is based on cases previously, the cases that our laws are based on today are based on either authoritarianism, racism, or to keep marijuana from competing with the big businesses, and that's the war on drugs. I'll let you guys watch this.
A civil suit is not parallel to, inconsistent with, or collaterally attacking anything. As the 11th Circuit observed, every circuit to adopt the indications of innocence approach has mistakenly imported it from an unsubstantiated comment in the restatement. With very able counsel, respondent could not come up with any plausible defense of that added inquiry and focuses most of his energy on record-specific arguments from the certiorari stage that divert from the question presented. Respondent had a tall order. If he wants to inject his additional innocence inquiry into this federal statute, he had to show it was so well settled in 1871 that Congress would have taken it for granted. Instead, respondent openly admits that there was no such well-settled principle. This court's opinion can end there. Even pretending that respondent could fight to a draw not be a basis for reading his additional inquiry into the statute. Respondent is nowhere near a draw. As the 11th Circuit detailed, all jurisdictions except for Rhode Island adopted petitioner's rule and understood that the dismissal of charges terminates the proceeding in the accused's favor. I welcome the court's questions if there are any.
Mr. Ali, before we get to the termination issue, favorable termination issue, don't we?
Okay, so let me explain something. I have to kind of put the camera on a funny angle so you guys can hear the audio properly. Clarence Thomas, who you're going to hear speak right now, he's out of touch with the entire world. Clarence Thomas, if you read his opinions, he's completely insane. There's something wrong with him. Really. He didn't talk for the first 10 years he was on the Supreme Court. He didn't say a word. You hear him, he's the first one to speak now. And the reason why he didn't talk for 10 years is because when you're appointed to something for life and you get ultimate power, then what he did is he didn't talk for 10 years so that he could then say 10 years later, well, I didn't talk for 10 years when I was first on the court. And then as he ages, he could tell that to new people coming in. And then as he ages, 20th year, now he has more seniority anyway. It was a power move.
Have to address whether or not there actually can be a malicious prosecution case or claim based upon the Fourth Amendment seizure.
So I don't.
An unreasonable seizure under the Fourth Amendment.
So this court held in Manuel that there is a Fourth Amendment claim for unreasonable seizure pursuant to legal process, and that is the claim that is before this court. And I want to be very clear on this. Petitioner is not asserting a standalone malicious prosecution claim. Respondent before this court now at the merit stage is asserting some sort of confusion in that respect because respondent used the malicious prosecution label that is used throughout all of the circuits. As Chief Judge Pryor put it, that's the shorthand for this Manuel claim. So, we think the court has already decided that the claim exists, Your Honor, but the role that the analogy to malicious prosecution plays in this case is a particular one, and I'm happy to address that, Your Honor.
Please.
Yeah, so our position is that the Fourth Amendment does not have a favorable termination element. This is not an argument that we import the elements of malicious prosecution into the Fourth Amendment. But petitioner brought his Fourth Amendment claim, his claim under Manuel, using the vehicle of Section 1983. And this court has held that when Congress enacted Section 1983, it is reasonable, because it's a species of tort liability, to assume that Congress would have taken for granted certain well-settled common law tort principles when it enacted the statute. And so in the favorable termination rule, or the analogy to malicious prosecution in this case, takes place for all of the reasons that it took place in McDonough and in Heck. What this court said is that when you were bringing a civil suit which challenges the initiation of a state judicial proceeding, that the relevant tort you analogize to is malicious prosecution, and in particular, that the favorable termination rule comes into play under Section 1983.
What was the...
Okay, so right there. So what he's saying is that this court has already ruled that, and you would want to stop right here just so you know, and you would want to research McDonough. You would want to stop and research it. You would want to read McDonough and Heck. That's what you would really want to do right now. I would go read both of those cases, so I really have a true understanding of what the case precedent, the case previous to this, is based upon. Because all case law, all Supreme Court case has to be based on the values and the exact verbiage of the Bill of Rights and the Constitution. And it's not. So it's pretty frustrating. But this is the case that came out 2 days ago, Clark versus Thompson, that allows us to go after the cops for malicious prosecution.
Initiation, where was this initiated? The state proceedings?
This was initiated in New York State Court.
No, so I'm confused. Which seizure are you, at what point was petitioner seized? And that is the basis for this claim.
Sure, Your Honor. So I promise to answer your question, but let me just say the question presented here presumes a seizure pursuant to legal process. We don't think the court needs to get into the question of what the particular seizure was.
I think you're conflating two things, and I just want you to identify exactly where the seizure is and exactly where the proceeding begins.
Right. So in this case, respondent never challenges below, but there are two seizures in the record here. First, as the United States admits in this case, the criminal complaint was filed while Mr. Thompson, while the petitioner was still in custody, and so legal process was initiated, and we will have to show petitioner, if respondent is allowed to raise it at this late stage, the petitioner's seizure, for the purposes of this particular seizure, will have to show that petitioner's seizure was caused by the initiation of legal process, meaning he would have been released had that false criminal complaint not been filed. The second seizure in this case, which has also been unchallenged since it was specifically ruled upon at the summary judgment stage and deemed proven at trial, we heard nothing from respondent on this seizure either, is that there's Second Circuit precedent clearly holding that the restrictions when being released on recognizance and the compelled attendance in court hearings constitutes a seizure within the meaning of the Fourth Amendment. Our position in this case, though, and I think what's critical for this court to know, is that the Second Circuit is perfectly capable of resolving those kind of late-breaking arguments that respondent is making before this court.
So now I'm going to show you guys what this case was about right here. Here are the facts of this case right here. I'm going to read them out loud, and we'll just go over it real slow together, okay? So this case, Clark versus Thompson, that allows us to sue police for malicious prosecution. It says, I got to look off screen, I'm sorry. Kamala Watson was staying with her sister and her sister's husband, Larry Thompson, when she dialed 911 after seeing a diaper rash on the couple's infant daughter and mistaking the rash for signs of abuse. No, she was actually mentally ill, is what they're saying. In response, 2 emergency medical technicians arrived at Thompson's apartment building to investigate. The EMTs saw nothing amiss and unaware of Kamala's 911 call. Thompson told the EMTs that no one in his home had called 911. He asked the EMTs to leave, and they did. 4 police officers followed up to investigate the alleged child abuse and instigated seeing Thompson's daughter. Thompson asked to speak to the officer sergeant, and after being denied that request, asked whether the officers had a warrant, which they did not. Nevertheless, they physically tried to enter Thompson's home, and when Thompson's attempted to block the doorway, the officers tackled and handcuffed him. Man, does this sound familiar? Does this sound familiar to you guys? He was arrested in his own house and taken to jail. And they're skipping all the steps of the feel up and the whole process of the torture, where he spent 2 days in a dungeon, and people, they don't just understand it's a dungeon. He was charged with resisting arrest in his house, obstructing justice, obstructing governmental administration. Isn't that what's going on constantly right there in Lawrence County? And about 3 months later, the prosecution dropped the charges against him. Yeah, because he was in his own house, stating the people are dismissing the case in the interest of justice. Of course, because it's wrong. Thompson filed a Section 1983, which is exactly what we're doing tomorrow, filing 2 of them, for malicious prosecution claim against the police after officer involved. A federal district court granted judgment as a matter of law in favor of the defendants on Thompson's malicious prosecution claim due to his failure to establish favorable termination of his criminal case, which is required under the binding Second Amendment precedent. The appellate court affirmed. Question. So when it says question right here, this is the constitutional question, because remember, the Supreme Court, what they do is they interpret the law, and they've been just a wee bit off for a really long time. So the fact that they got this right is actually a moment to celebrate. Okay? And here's the constitutional question. Does a plaintiff who seeks to bring a civil rights violation, a 1983 is a civil rights violation, action alleging unreasonable seizure, grab you and put you in torture cuffs, that's a seizure. And was the seizure unreasonable? Everything, the whole way they've screwed us over in America is through this one word right here called reasonable. I swear to God, that's how they screwed us. And so, pursuant to the legal process, that the criminal proceedings against him formally end. So in other words, does your criminal case have to be over before you can sue the police for not inconsistent with his innocence? You see? So I'll read it again plain so it's clear. Must a plaintiff who seeks to bring a civil rights action alleging unreasonable seizure pursuant to legal process show the criminal proceeding against him formally end in a manner not inconsistent with his innocence, and that the proceeding end in a manner that affirmatively indicates his innocence. And in a 6-3 opinion, do you see this? So this shows you left, right. So Kavanaugh, who's actually on the right, let me go by. Kavanaugh's on the right, but he's over here. Roberts is on the right. Breyer's on the left. Sotomayor's on the left. Kagan's on the left, and Amy's on the right. And then Samuel Alito and Clarence Thomas, these are the two biggest assholes on earth right here. You want to see two guys who are absolutely despicable, who are not worth respect at all? These two guys right here. Samuel Alito is a disgusting pig sucker. You have no idea. Disgusting. And Clarence Thomas is completely lost. And his wife, Jeannie, they're nutballs. They're truly nutballs. And Gorsuch, he works for the Chamber of Commerce. He works for the Chamber of Commerce. That's who he works for. He doesn't work for you and me. He works for big money. I promise. I promise. I promise. I've done lots of videos on this. Okay. So now a plaintiff, and here's what they are going to hold. So here's the conclusion. This is how these guys voted. The conclusion and how they voted 6-3. These guys voted for that you could sue, and these guys said you should not be able to sue the police for malicious prosecution. These guys said nope, don't sue the cops, and these guys said yeah, you can sue the cops for malicious prosecution. You see? Do I have a black screen, really? Can you see now? Can you see now? Are you there? Can you see now? Is that black still? No, they cut me. Let me try. Black, I'm still black. I can see you guys. Lame. I'm gonna restart. I'm gonna restart this. I'm gonna keep going because I'm gonna read the opinion of the court here. So I'm gonna restart this. Am I back? Am I back? Okay, guys. Hey, let's keep reading this. So those guys, Alito, Thomas, and Gorsuch, they voted against us being able to sue cops for malicious prosecution. And since the other 6 voted that we could, now all through Lawrence County, when you charge them with tampering with evidence, obstructing justice, trying to attack a cop, trying to flee, or I have my brain. Brain fart. Trying to flee police. Whatever. Let's get back to this video. I want you guys to really learn that about this malicious prosecution thing, because all through America right now, you can sue for your civil rights being violated, and I'm going to teach you guys step by step how to fill out that paperwork. I'm going to teach everybody here. I'm going to teach you guys. Everybody's going to learn. 92% of civil rights cases are brought by the person who was violated. I told that to Deborah in December. She sent me her filing today. Deborah, congratulations. I'm so proud of you. You did it. You did it. I'm proud of you. So now let's get back to the case, guys. Let me see if I can flip my camera around here. Okay, so the question was, can you sue police for malicious intent, malicious prosecution, or not? And so these guys over here said no, you could not, and these guys over here said yes, you could. I'm really surprised with Brett Kavanaugh's voting record this far in his thing, but I'm not at all surprised by Neil Gorsuch. He's a horrible addition to the court, horrifically bad. I'm surprised Amy Coney Barrett, she voted that way. Okay, so now let's go down here and read the exact what they said. And I'll read this to you. A plaintiff wishing to bring a 1983 a civil rights violation for malicious prosecution need only show that his prosecution ended without a conviction. Justice Brett Kavanaugh authored the 6-3 major opinion holding that Thompson satisfied that requirement and reversed the judgment of the lower court. To succeed on a claim of malicious prosecution under a 1983, a plaintiff must show 1, the suit or proceeding was instituted without probable cause. So in other words, they didn't have probable cause. I'm sorry, there it is. They didn't have probable cause. Okay. The motive in the instituting the suit was malicious. So in other words, if they charge you with like trafficking, that was the 5th one. If they charge you with trafficking and you're just a drug abuser, then you fit that position right there. Because if they charge you with trafficking, you can sue them now. If you're just a drug user and you're not a drug trafficker, do you see what that does, that second one? That for a purpose other than bringing the defendant to justice. And 3, the prosecution terminated in the acquittal or discharge of the accused. The purposes of this 3rd element, favorable termination of the underlying cases are A, to avoid parallel civil and criminal litigation. B, to prevent inconsistent civil criminal judgments and to prevent civil suits from being improperly collateral attacks and criminal proceedings. Most American courts have considered favorable termination to mean simple, a prosecution that ends without conviction cannot be revived. That would be double jeopardy. That's against your constitutional rights. Thus, if the prosecutor abandoned the case and the court dismisses the case without stating a reason, these satisfy the 3rd element of malicious prosecution. Acquittal of the defendant is not required. Respondent claims to the contrary are not persuasive. And then here's Samuel Alito. If you ever read Doe versus Grudy, that case that Samuel Alito wrote a dissenting opinion, I wouldn't even want to read what this guy wrote. He's horrifically bad. In Doe versus Grudy, let me just tell you about that a little bit. Doe versus Grudy, I believe it's going to be, I'm not going to know the year off the top of my head, I don't think, but I read the case. Doe v. Grudy, Grody, Samuel Alito, put that into your Google. Read his dissenting opinion where they strip searched a mother and a 10-year-old daughter, and they surrounded her with a bunch of men, and they made them strip. And they actually found in favor of that mother and daughter and said, no, you have to give her a restitution or whatever. I can't remember, I don't remember what the holding was about specifically, but the mother-daughter were allowed to sue and they were justified in their actions. However, when you get a 6-3 decision, the person who's dissenting, or 2 or 3, like in this case, they will have a dissenting opinion on the case. Samuel Alito's dissenting opinion in Doe versus Grudy made me lose all respect for him as a man. The justification he wrote of strip searching a mother and a 10-year-old daughter. What's so important? What's so important to strip her dignity? To strip a 10-year-old child's dignity? Read Samuel Alito's opinion, and you will not be a fan of his. You will not be a fan of Samuel Alito after you read that. It's disgusting. Okay, let's go back to our case here now. So now you understand a little bit about what this case is based on.
Remand.
Suppose the case had gone to trial, the criminal case had gone to trial, and your client was actually convicted based on evidence entirely having nothing to do with the criminal complaint. Would you have a claim?
Well, if he was convicted, we wouldn't be able to satisfy the favorable termination rule, so there would be no claim.
Even though he was arrested without probable cause, you claim? Suppose he's arrested without probable cause, he's held for trial without probable cause.
No probable
Then,
cause.
At trial, the state comes up with completely different evidence, and
Let me explain what that is. So you guys understand. When you get arrested and there's no reason you should be arrested, you haven't broken any laws, you didn't do anything wrong. You've been arrested for no good reason. That's called arrested without probable cause. This gentleman was arrested because his crazy sister-in-law, she was a nutbag, she called 911 when she saw a diaper rash. She was schizophrenic, and she believed the baby was being abused seeing a diaper rash. When the cops got there, the guy said, first he sent the EMTs away, said, "What are you guys doing here?" And the EMT said, "We got a 911 call from here that there's a baby in distress." And he said, no, there's no baby in distress. You got to go. And then a few minutes later, 4 cops showed up, and the 4 cops said, "We want to see your baby." And he said, "Go pound sand and enjoy that sound that pound of the." I'm parched, I'm sorry. And so they threw him on the ground, put him in handcuffs, put their knees in his back, put their fingers up the crack of his butt, took him to a dungeon, made him turn around, squat, cough, strip searched him, and then shoved him in a cell with a bunch of other people where he had to join a gang, make a decision on his gang affiliation that night when he was just sitting on the couch watching TV with his wife and his brand new baby. That's the power of police. They can just come into your house, say, "We're got a call about your baby," so you go on the ground. Okay, so then after that, he said, "I want to sue them." Because what the state did then, just so you know, let me tell you what the state did. The state then didn't charge him. They just, you know what, we're just going to let this all go. No, you're not going to let it go. No, we are not. We are no longer letting it go. If you don't know how to file a civil rights litigation lawsuit on your own, I'm going to be putting the forms up on my website. I'll be showing you the 2 for tomorrow. And then next week, you get to see Unez's in Dallas. Hey, Forney Police Department, I'll see you guys next week. We're filing a civil rights lawsuit against you. We'll see you there, okay? Because we're no longer accepting these things, just like in Thompson versus Clark. He did not accept being strip searched and turned around and turned to cough and looked up his booty. Okay, he didn't like it. He ain't gonna put up with it. We're not gonna watch the rest of this, all right? No, that's Edwards versus South Carolina. There that is. Without probable cause. That's insane.
Irrefutable evidence, and this individual is convicted. Is there a claim? A Fourth Amendment claim?
So there is a Fourth Amendment violation in your hypothetical, but it is not cognizable under Section 1983. And this is an important point, so just to explain a little bit more, so a couple of responses. It is always the case when the court reads a prerequisite into the statute, separate and apart from the constitutional violation, that certain constitutional violations will not be actionable. So that was true in McDonough, right? You could have had false evidence introduced to instigate the criminal proceeding, as your hypothetical just posited. It could have been evidence that was likely to have affected the jury's verdict, but the plaintiff could have been convicted, and he would not have a claim because of the favorable termination rule. All the same in McDonough, I could give the same hypothetical in the context of Heck. So that is always true in these cases. Now, I think it's actually...
Well, my question is, why should there be any kind of a termination element to this claim? It's a claim that there was an unreasonable seizure.
So
he's being a smartass. Samuel Alito right here. He's saying, well, why should there be any kind of termination element? In other words, an end to when you can file your claim. If it's a claim that's an unreasonable seizure, you should just always be able to file a claim for an unreasonable seizure whenever you want. That's essentially what that question is by Alito. He's being a smartass. He's going, well, there should be no termination at all. Think about him talking like that. That's literally what he's doing right there.
That have to do with whether, why is that at all dependent on the outcome of the trial?
So I think the court...
The trial doesn't even matter.
...distinguishes between those Fourth Amendment...
What if he's guilty? Does that matter? That's what he's saying.
Legal process, as the court put it in Wallace and in subsequent cases like McDonough, or in subsequent cases, and seizures pursuant to legal process. And in McDonough, we think the court confronted this question, the exact same question, and it said, when you have, the gravamen of the claim necessarily challenges the initiation of state criminal proceedings, then the analogous tort is malicious prosecution and the favorable termination rule. I don't want to fight too hard on this, because if there's no favorable termination rule at all, then the Second Circuit clearly erred in requiring affirmative indications
Nice.
of innocence, and I'd be glad to talk about the problems with that rule. But
Very good. Very.
That's all right.
He
Because
pushed back.
That's what I'm a bit mystified by. If the Fourth Amendment doesn't require termination at all, or malice, why would you fight those things? Wouldn't it be easier for your client to say it's a false imprisonment claim, starting whether by judicial process or by arrest, as in this case, and it was unlawful from the start?
you know, we'll take the win on the alternative grounds. We think the best and, you know, really only plausible reading of this case is that there's a favorable termination are actually significant, right?
So you actually want to have to prove favorable termination. You're just quibbling over what that termination should look like. How favorable it has to be. You say not so favorable, they say very favorable.
Right.
You're willing, you want to prove that. And you want to prove malice too?
Well, Your Honor, I think that the inquiry would be different for malice, right? That, you know, this is and let me come back to your first question as well, but just because
You
you
haven't
raised
fought
malice
that though. I
twice.
mean, malicious prosecution, you know, has always required proof of malice, and you don't seem to dispute that. And you seem to be making it awful hard to prove a Fourth Amendment claim.
Well, Your Honor, I think we have to remember that we're engaged in interpretive inquiry here, and I think really
I'm very concerned about that too. And one of the things I've noticed is this court's never recognized a malicious prosecution claim under the Fourth Amendment, and it's reserved the question a couple of times now, at least. Isn't it time that we answer that before we decide what the elements of that claim should look like?
I think the court can very comfortably say all the parties agree there's no standalone malicious prosecution claim under the Fourth Amendment. I don't think that answers the question before the court.
Hold
and the
on.
analytical framework.
That was a big moment there, I think. So you agree that there is no standalone malicious prosecution claim under the Fourth Amendment?
In which you just pull in the torts of malicious prosecution into the Fourth Amendment.
Okay.
We don't believe the origin of this favorable termination rule is the Fourth Amendment. It is the analytical framework that the court clearly set out in Manuel and that Chief Judge Pryor adopted, right?
Okay, you have your claim is a Fourth Amendment claim, right?
Yes.
And you want to import into that an element from the tort of
What?
malicious prosecution, right?
The Fourth Amendment has no favorable termination.
Is it better?
element,
Can
Just
you guys
like
see?
the due process clause has no favorable
Let me pause it.
termination element or
I
no
got you.
probable cause element, right? That would
Sorry, guys. Hold on. I'll fix it. Are we back? Did we get back? I didn't walk away, man. I'm watching with you. Are you there? Am I back? Am I back? No photo? No? Can you guys hear me? Does that work? Oh, Lord. Damn it. I'm still here. You can still hear me, huh? Should I start this audio? Should I start a new one over? I don't want to. Okay, you can't hear me. Audio's good. Sounds good. Can you hear me? Bummer. 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 You guys want to listen to this? But I want to show it to you too. Maybe I should stop it and just restart it. Let me try something. Nuke it from orbit. I turned it on and off. I restarted my app. I wonder, did that work? Am I back? Yes. Okay, I'll try not to zoom in. I'm so sorry. I'll bring the computer closer. I'm really sorry. That sucks. I really want to go through these oral arguments. You know, this is so important because this lets you know that you can sue. If the cops just grab you without probable cause, you know, thank God that there was some semblance of sanity there that made sure that our rights were protected. Okay, cool. Let's go back to this video because and by the way, I'm listening with you guys. I mean, obviously, I'm scrolling down the screen. I don't walk away. I'm sitting here watching and I'm learning with you guys. You know, I so want to break off and read the other couple cases that this is based on. I want to read McDonough so bad. So let me just keep going. I want to read McDonough so bad. Do you want to post that, one of the mods? This case, the case on this is McDonough versus, was it Lewis? I can't remember. Let's keep watching. And I will not zoom in. I'm gonna try. I mean, let me see what this looks like without zooming. Yeah, we're gonna have to just be that far away.
McDonough. The court didn't
McDonough.
say we're importing the favorable termination rule into Section 1983, and that means you now have to prove an absence of probable cause under the Due Process Clause. It's the same. I think that's conflating the inquiry.
Does it have any kind of a termination element? Does termination have anything to do with it?
Well, okay, so the interpretive inquiry that we're engaged in here says that this is a species of tort liability enacted by statute. So it makes sense at the initial, the first step, to assume that Congress would have assumed that certain prerequisite that existed at common law would be read into the statute. Now, this is where we get to the malice question, which is a different question, because the second stage, with which the court set forth in Manuel, and which Chief Judge Pryor also applies, is that you have to look at whether that well-settled principle is consistent with the statute that Congress actually enacted, meaning the purpose and values of the Fourth Amendment. You know, the court, I think, would come to the different conclusion in the context of reading malice into Section 1983, because the Fourth Amendment itself says reasonable, objective inquiry. And so it's pretty hard to square a malice requirement.
So you don't think we should have malice, and you don't think we should have a favorable termination requirement. And so why wouldn't we just have a Fourth Amendment, as in Manuel claim, most analogous might be a false arrest?
So, Your Honor, I want to be very clear here. I don't think there should be malice or Fourth Amendment read into the Fourth Amendment. I do believe that one brings a claim of unreasonable seizure pursuant to legal process, just like when one necessarily challenges the initiation of legal process under the Due Process Clause, that Congress would have assumed, and I think this is just McDonough, would have assumed a favorable termination rule, and that rule is consistent with Section 1983. So we
So
do
important.
think that the best reading of this court's case law is that there's a section, that there's a favorable termination rule. And if I could come back to just...
You don't want it to be just false arrest, though, because you lost the false arrest claim
Well,
in this case.
Your Honor, I think it's pretty hard at this point to get to false arrest as the analogy. I mean, the court said that at bottom, the reason that the Due Process Clause claim, the assumed due process claim to McDonough was analogized to malicious prosecution, was that it was undertaken pursuant to legal process. That was the language in McDonough. And Heck said, I mean, it's pretty clear, the common law cause of action for malicious prosecution provides the closest analogy of, to claims of the type considered here, because unlike the related cause of action for false arrest or imprisonment, it permits damages for confinement imposed pursuant to legal
There's
process.
a misfit, I think you're acknowledging, between the Fourth Amendment.
I want to go back, but I don't want to fuck anything up here. Okay, so you can collect damages for wrongly being confined. Did you? I'm going to see if I can roll it back. 1503. Yep, I can roll it back. Okay, I'm gonna roll this back. Listen to what they say here. If the cops arrest you and put you in a dungeon, and you have a video that they don't have probable cause, you have to have your video. That's what saved Kent, or Kent would be facing 2 felonies, but instead Kent's gonna get paid, right? I'm gonna let it play. Ready?
To claims of the type considered here, because unlike the related cause of action for false arrest or imprisonment, it permits damages for confinement imposed pursuant to legal
There's a
process.
misfit,
It permits
I think you're acknowledging, between the
damages
Fourth
for
Amendment and
confinement
this kind
before
of
legal
malicious
process.
prosecution kind of claim that the courts of appeals have generally recognized. But I think you're telling us, well, just muddle along with that and don't worry about it, because that's not the question presented. Is that an accurate summary of what you're suggesting?
We think it's pretty clear that for the reasons stated in McDonough, the favorable termination rule exists. We do think, and I think I'd like to bring the court back to the question presented, because I do think that the common law adopted a very, very clear rule here that is easy for courts to apply, right? 2 functions for the favorable termination rule. First function, let's try to avoid parallel litigation of probable cause and guilt. How do they resolve that? The solution is require that the proceeding be over.
Right.
Second function, let's avoid inconsistent judgments and collateral attack of judgments. How do we ensure that that function is met? Let's require that there have been no conviction at the end of the proceeding.
No conviction.
Very straightforward rule. We don't think that's an accidental thing, as Justice Scalia pointed out in his Eck majority. The reason the court turns to the common law is because those rules were developed over the
Well,
centuries.
that's true. And I'm now slightly confused because I usually read briefs, and I thought the question presented, I didn't know about all this 1983 business. It's something they said.
Okay, so Breyer here is going to show you his absolute arrogance. His total, he is the most snobby liberal you will ever listen to talk. And he will say that he's confused. Breyer's a giant asshole. He's a giant asshole. Trust me. So he's a giant asshole. But let him continue to talk in his uppity, prickish, has nothing in common with you way. And
In the Second Circuit, a plaintiff asserting a malicious prosecution claim under 1983 must show that the underlying criminal proceeding ended in a manner that affirmatively indicates his innocence. And we're arguing about whether that's so. Is that right?
Right.
now,
Okay, if
again,
that's right, what do you do
is it a black screen?
if, as you want to say, no, it doesn't?
Right.
Okay, so the assistant DA is there testifying. Why do you not prosecute this guy? You dismissed it. To tell you the truth, Your Honor, we have hundreds, maybe thousands of cases. We have a very big staff. We can't handle all this. And so we, in fact, do dismiss quite a few cases, an awful lot, because we just can't handle them. We take the more serious ones. Why'd you dismiss this one? Honestly, Your Honor, I can't find anybody in the office who remembers. Okay, but I can tell you our general policy. Yeah. What do you say?
Your Honor, in that case, there's been no conviction, and it sounds like the proceeding is over if the charges were dismissed, and nothing stops the plaintiff there from bringing his Fourth Amendment claim for unreasonable seizure pursuant to legal process.
And so what the DA will say, I'll tell you what, Your Honor, go ahead, hold it.
These
words
words are just so good. So let me give you the words. Nothing stops the plaintiff from bringing his Fourth Amendment claim for unreasonable seizures pursuant to legal process. So just so you guys know, tomorrow in Cincinnati, we file against Pam. Nothing stops me, Chille, the plaintiff, from bringing a Fourth Amendment claim, unreasonable seizure of me, for unreasonable seizure pursuant to before the legal process. Do you follow? These words are freedom. This is what God intended right here. This right here. That literally is what John Locke would say are God's divine morality, that you are free, that you are born free. This is the epitome of your freedom. I can take claim against any government agent that puts me in a dungeon before I have a legal process.
Triple our staff, or we're going to have to prosecute a lot of people who have very, very appealing personal conditions, such that we feel we're going to be doing injustice if we go bring a case against them in a criminal court. And you say?
Your Honor, the favorable termination rule was never intended and never served the function of filtering cases that are, have foundation or don't have foundation. So we think that, the manner of dismissal can go to whether there was probable cause or not. The example you gave to me sounds like it would be pretty neutral as to whether probable cause existed or not, but it would not foreclose a civil suit.
Just one more question, counsel. You do not embrace the Lasker test, right?
We do.
Well, but it seems to me you're focused much more on finality than assessing whether that finality is consistent with innocence.
So, Your Honor, the Lascar test was that there's no requirement of an indication of innocent, and what you were looking for was whether there was a judgment that is inconsistent with innocence. And this is important. It takes place at a categorical level, and Chief Judge Pryor says that. He several times says, inconsistent with innocence, that is, it ended in a conviction or admission of guilt.
And you say in your brief that the best thing that can happen for a defendant is to have the charges dismissed, right?
Yes.
Well, what if they're dismissed pursuant to an agreement that says, okay, you were the number 2 person in this vicious gang and you've killed 5 people and all that, but we want you to testify against the number 1 person, and in exchange we're going to dismiss the charges. Is that consistent with innocence?
Well, Your Honor,
It's a dismissal, and it's a pretty good thing for him, I guess, but I don't think anybody would look at that and say, that's not inconsistent with your innocence.
under our test, the dismissal in that case would be a favorable termination. But as the common law courts recognize, the manner of dismissal, and so that agreement would all but doom the Fourth Amendment claim. That person's never going to be able to prove that there was no probable cause, or presumably at least there's going to be a lot of evidence here. And if there's an agreement, all but is stopped for reasons completely separate and apart from the favorable termination rule, which was, as common law courts put it, a technical prerequisite protecting against parallel litigation, inconsistent judgments, and collateral attacks. So what we're looking for is what common law courts looked for. It's what the rule in Heck and
Common law courts really did. I stole this bread to feed my starving children. And the DA says, okay, I understand. Unlike, etc., I won't prosecute you. Yeah, you say, good, wonderful. We now have a malicious prosecution claim, right?
So, Your Honor, common law courts carefully guarded the technical favorable termination prerequisite. And they understood that what Your Honor just described very much might doom. I'll direct you to Clark v. Cleveland, which is really kind of the canonical case by the New York Court of Appeals. It recognized that certain compromises or forms of mercy may be, I think the word it used, insurmountable when it comes time to actually prove that there was an absence of probable cause, but they did not conflate it.
I stole the bread. I mean, it's Jean Valjean. I stole it. Yeah, to feed my starving children. I'm just saying, your view is, there is a malicious prosecution claim. This is great. Well, I know 4 lawyers who will bring it, and there we are. And so next time, that DA doesn't...
No, Mr. Breyer. I'm sorry, sir. I'm sorry, Mr. Breyer. If I can direct Stephen Breyer directly here, there is a malicious prosecution claim because when you arrest someone, put them in torture cuffs, throw them in a dungeon, in a stinky, dirty dungeon that you wouldn't put your dog in. If your dog went in that building, you would call your dog back out. If someone treated your dog the way cops treat us, when you get arrested, you would beat the shit out of the person who treated your dog that way. If they did to your dog what they do to human beings. Mr. Breyer. So Mr. He's mocking. He's the most pompous, arrogant ass. There's a book that Stephen Breyer recently wrote called Deference, I think. And deference means respect. And he pleads that the people should respect the Supreme Court more. You can't even read it. He's such an arrogant, pompous ass. But he doesn't know what it's like to be put in the torture cuffs. So he's mocking it, saying that, I guess anybody can. So what he's saying there is, when you steal the bread for your starving children, when you get arrested, he's saying that then when I, the judge, say to him, I understand you stole the bread, so I'm going to let you go. Then his lawyer sues because he got arrested. That's what he's saying. But what he's not taking into account the treatment of what it's like to be arrested in the United States of America and what it's like to go to that dungeon.
Give in to that argument.
Well, remember, Your Honor, everyone here agrees that petitioner's going to have to prove his claim. He still has to prove the absence of probable cause, he has to prove causation, and he has to overcome, had it not been asserted, the defense of qualified immunity.
Thank you, Justice Thomas. Anything further? Justice Alito?
As I understand what happened, your client was arrested without probable cause.
Yeah,
And eventually he was held for 39 hours.
39 hours.
And then released on his own
Each one hell.
cognizance. And sometime during that period, the criminal complaint was filed.
He filed it before he got out of jail.
Released any sooner had the criminal complaint not been filed.
Your Honor, what we'll have to prove, and at least one of the seizure theories, we of course have the Second Circuit precedent that compelled attendance and the conditions are a seizure, but setting that aside for a moment, Your Honor, what we would have to prove for that first seizure is that he would have been released had that false criminal complaint not been filed. In other words, had respondent told the truth of what had happened to the prosecutor, he would have been released then because he had done nothing criminal. There would have been nothing to hold him for. The reason he was held was because, and solely because, and that's the causation piece, solely because of fabricated evidence that was produced by respondent.
You'd have to prove what went on in the DA's office. So the assistant DA who was handling this would say, well, you know, I expected this police officer to come tell me what actually happened before the initial appearance, and if I wasn't satisfied at that point, we would have released him.
So, Your Honor, on the causation point, these multiple actor cases, causation is really hard to prove, and that's why we don't see a lot of these claims unless there's really serious misconduct being alleged. And what you typically have to prove is either a deliberate or reckless disregard for the truth, and it's precisely because of what Your Honor just said. If you don't have, when you have that, that's when you can say that it effectively, prevents the prosecutor from making an independent judgment as to probable cause. And on top of that,
Okay. So he said, and I heard, he said, the reason why you rarely see these is because whatever, blah, blah, blah. The reason you rarely see the federal civil, they filed the civil wrongful prosecution claim against the police while he was still in jail. He called his lawyer and said, they arrested me for no reason, took me out of my house, put me in torture cuffs, stripped me down, treated me like an animal. I want to sue them. He had the lawsuit filed before he was out of jail. So, and then he said you rarely see these cases because, I'll tell you why, because you don't know how to do it. And so I'm going to teach you. I'm going to show you. I'm going to show you every single step. The 2 lawsuits tomorrow, I'll show you every page of them. I'm going to teach you guys. We're not going to put up with this shit anymore. 92% of federal civil rights lawsuits are brought by the person who was assaulted by this filthy organization that we're going to change to transparency.
you typically have to prove that it was the sole basis for initiating the proceeding, because if there's independent probable cause, well, then you can't satisfy the causation requirement.
And your claim is that your client was continuously seized after that point, even though he was released on his own recognizance because he was required to come back to court. Is that it?
Yes.
So, Your Honor, there was a seizure at the time that the legal process was initiated.
Grab me out of my house.
I don't think the way the court has looked at it is that it's a continuing seizure. I think it's just that that claim doesn't accrue until favorable termination is how we would look at it. And under the Second Circuit precedent that respondent never challenged below, there were additional seizures by virtue of the restrictions when he was released on recognizance and on the compelled attendance.
By virtues of the restrictions.
Seizures. The judge?
Under the Second independent probable cause.
Listen
well,
to
you
this.
Can't satisfy the causation requirement.
And your claim is that your client was continuously seized after that point, even though he was released on his own
Follow this
recognizance
argument.
because he was required to come back to court. Is that it?
So, Your Honor, there was a seizure at the time that the legal process was initiated. I don't think the way the court has looked at it is that it's a continuing seizure. I think it's just that that claim doesn't accrue until favorable termination is how we would look at it. And under the Second Circuit precedent that respondent never challenged below, there were additional seizures by virtue of the restrictions when he was released on recognizance and on the compelled attendance.
Who affected these subsequent seizures? The judge?
Under the Second Circuit case law, what's the theory? Is that Your Honor's question?
Under the correct understanding of the law, as you are explaining it to us, who effected the seizures that occurred after the initial appearance?
So, Your Honor, I think that the best authority this court has on that is Justice Ginsburg's concurrence in Albright. We don't think the court should get into any of this. Remember, like just last term, the court decided a question about what seizures meant, and it took 50 pages of historical analysis to get to that result with a divided opinion. This is an issue that respondent just injected to the case in the first instance in its brief in opposition. We think what we need from this court is a resolution of the question that was decided by the Court of Appeals, whether there is an affirmative indication.
Did you guys hear that? There's a 50-page argument under what seized is. How many people have been seized? How many people have been seized by the police? You have to get on your knees, lay on your belly, knees in your back, knees in your neck. How many people have been seized by the police? Okay? They have to do a 50-page analysis of what seized is. I just want you to point out how ridiculously stupid these people are who have nothing in common with you and me and are not voted in by the people. I just want to point out what atrocious system that an unelected Supreme Court is.
Of innocence requirement under Section 1983 so that we can move on and litigate these questions about the merits.
Am I to understand you correctly that what you're claiming is a Manuel-type fabrication of evidence to initiate the charges?
Yes.
And how are you not doomed by your adversary's fair trial claim where the jury found probable cause to arrest? Pardon my ignorance, but I thought that the jury there was charged that any probable cause to arrest on any charge was enough, and the jury voted for respondents.
Right.
So why doesn't that doom you here?
So, Your Honor, I just want to be precise because there are two claims. So you first mentioned the fair trial claim, which is the due process claim. That claim doesn't turn on probable cause at all. There was no instructions related to probable cause with respect to the fair trial claim. That arises on a due process standard, which turns on things like materiality at trial, which have nothing to do with a Manuel claim, right? So if the jury concluded that the fabricated evidence would not have likely affected a jury's verdict at the criminal trial, that would be a basis for rejecting the fair trial claim. It would not at all be a basis for concluding there was probable cause at the time that petitioner was seized. So they're just two different constitutional claims addressing two different things. Where probable cause came in, Your Honor, was with respect to the false arrest verdict. And, both the false arrest verdict, and I'll note these are, again, all arguments that are being raised at kind of a late-breaking stage here that we think the Second Circuit is perfectly capable of dealing with. But the false arrest and the unlawful entry claims that responded.
They broke into his house.
All of those were assessed from before the officers even entered Mr. Thompson's apartment. When you have officers responding to, on respondents' own terms, what was kind of an ongoing child abuse claim. The fact that the jury might have found probable cause at time one with that information does not at all establish that there was probable cause, many hours later when the false criminal complaint was filed. It doesn't even necessarily relate to the same crime.
All of these side claims that Justice Gorsuch and Justice Alito have asked you about, whether there is a Fourth Amendment claim, all of those issues, those have not been addressed by the Second Circuit. They were not raised below, correct?
That's right. Respondent's theory has kind of shifted throughout this. It was respondent in the Second Circuit who actually grounded all of these requirements in the Fourth Amendment below, and we were arguing, no, they don't come from the Fourth Amendment. There's no favorable termination rule or malicious prosecution tort in the Fourth Amendment. So we were advocating Justice Gorsuch and Justice Alito's points below, and we've stuck to the clear line of kind of this court's jurisprudence, which finds that when a claim necessarily challenges, for good reason, right? We're talking about challenging an ongoing state judicial proceeding, that you analogize to the tort of malicious prosecution and require a favorable termination.
Justice Kagan?
Mr. Ali, you said in your brief, and then you repeated it here in your opening statement, that if the common law courts were divided on the nature of the favorable termination rule, you win. And I'm just wondering why that's so. Why is it that if there's a draw as to the common law, we don't say, okay, the common law doesn't tell us much. We have to think about the Fourth Amendment and its purposes and our precedent respecting it. Why do you win if there's a draw on the common law?
So, Your Honor, I think it depends precisely on what the draw is about. I made that in context of the question presented, where what the Second Circuit has put forward is that there's an additional inquiry, right? It's not just that it's got to be terminated and that it kind of terminates in favor of the accused in our sense, right? That there was no conviction. Everybody agrees that at a minimum those are required. But what they're saying is there's also this additional inquiry into innocence. So this is where the mini trials come into play. This is where, we're digging into a criminal record to see whether there have been indications of innocence.
Yeah, I get that. But if half the courts do that and half the courts don't, why do you win?
Well, because what we're doing here is interpreting a federal statute. And if respondent wants to come forward and say, well, this federal statute has this additional requirement, I think he's got to have a statutory hook. And one of those statutory hooks, the only one we could think of, the one the Second Circuit thought was there, but it mistakenly replied on the restatement, was that was well settled at common law. And so, Congress, another way to put it is Congress would have only taken for granted that additional inquiry if it were somehow pervasive at the time. And to read it into an otherwise silent statute, I think that's what respondents got to show. It doesn't really matter at the end of the day, because as Chief Judge Pryor put it, we've got the well-settled principle. The vast majority of courts at common law applied our rule, and only Rhode Island applied respondent's rule.
Justice Gorsuch?
Right. So do you see what he's doing? What he's doing is he's continually pushing the holdings of the case precedent that his argument is based on. He went through and he read the exact holding of McDonough, and then he read the majority opinion, and then he internalized that. And now every time they try to push against him and say, well, how come you should be able to sue the police just for arresting you? He keeps on saying, well, the principle of law is that you can't be arrested unless there's probable cause by the Fourth Amendment. That's what he keeps on saying. He keeps on repeating that. You can hear it. His argument is very clear, and he's very, very good. This lawyer is very, very good.
Decide what the elements of a malicious prosecution claim are under the Fourth Amendment.
What?
If we're not sure such a thing exists.
Oh my God. Oh my
We are
God.
not asking the court to decide
Look at that.
the elements of a standalone Fourth Amendment.
You're asking us to decide what this element of favorable termination looks like in a malicious prosecution claim. And yet, as we discussed, counsel, we're not sure. You're not sure it should be under the Fourth Amendment. Maybe it should be under procedural due process.
Look at
Maybe
him.
the Fourth Amendment claim should look very different than a malicious prosecution claim because we're interpreting a statute in the Fourth Amendment. What do we do about that fact? What do we do about the fact that you're asking us to define an element of a claim that may not exist? How many cases should this court continue down the road of assuming that which may not exist?
So I worry I haven't been clear, so let me try one more time to do this. Our claim exists. It is the claim that the court recognized in Manuel.
Citing case.
Put that aside, because
No,
as I read
no,
the record, lots
no.
have shifted on both sides in this
No,
case. As
no.
I read the record, you raised a malicious prosecution claim below. And just work on this assumption, okay? And now you're trying to slide it under Manuel.
Slide it under Manuel, it's case
Let's just
precedent.
stick with a malicious prosecution claim. If that's what's before us, assume that's before us.
No.
What should we do about the fact, and if you could just answer the question, what should we do about the fact that we're not sure it exists? Shouldn't we answer that predicate question at some point?
Your Honor, we think the court could start its opinion by saying respondent is alleging that we we asserted a standalone malicious prosecution claim, and no such claim exists under the Fourth Amendment. That is not the argument petitioner is making here. And the question presented...
Okay, so
Do
then
it.
you
Tell-
say,
tell 'em.
yes, there is no such claim, but we still win anyway.
Well, the question presented presumes the claim is unreasonable seizure pursuant to legal process, which is the claim of Manuel. And there was
Yes,
no
case
confused
precedent.
stage when we used that.
I got that. Is part of this about the accrual rule?
Okay, so let me make something clear. You can't argue with Neil Gorsuch. You're not going to be able to argue with Brett Kavanaugh. In my old office, I had a list of all the schools that all of these justices went to. You can't sit and argue with Neil Gorsuch. He knows more data than you do. He simply does. He was high school, college educated. He went to the same high school as, he went to the same college as Brett Kavanaugh. He went to the top high school in America. He went to the best, I think he Yale, because Kavanaugh and Gorsuch have the same college track. He either went to Yale, I don't want to misspeak, but I used to have his whole education listed, and he's so well educated. You're not going to be able to argue with Neil Gorsuch. So what is the lawyer doing? He keeps pushing Manuel back in his face and saying, the judges said this previously. That's what he's continually doing. And he's doing an absolutely marvelous job. And Gorsuch is a pompous ass. He's trying to figure out how he can protect the state at all costs. Protect the state, but not protect the people. Not protect the fundamental principle of rule of law.
For the statute of limitations purposes, that a malicious prosecution claim doesn't accrue until dismissal. That's advantageous.
Well, Your Honor, I think it's. I think that there is. It does defer the claim. I mean, this favorable termination rule is a deferral of accrual. It's more just than that. It's advantageous. It's avoiding the problems that were identified in McDonough about forcing a defendant to sue the people who have made the decision to prosecute him, and then potentially waive his Fifth Amendment right of incrimination and give in to discovery. All of those same interests come into play in this claim.
You could stay a case though too, right?
Well, and that's exactly what the court rejected in McDonough, right? So the respondent in McDonough said, just stay it like in Wallace. And what the court said, very specifically, was, well, in Wallace, you were dealing with false arrest where there may never be charges.
I do have a few more questions. I hate to occupy so much time, but I got that one. Well, why didn't your client bring a malicious prosecution claim under New York law in state court, where the favorable termination requirement is just exactly as you describe it?
Well, Your Honor, because Section 1983 permitted him to sue
under his Fourth Amendment right.
You have choices in pleading, and I'm just curious, is there a reason why he didn't pursue it in state court with a more advantageous legal rule?
Fourth Amendment, dickhead.
I actually don't know. I wasn't involved at the trial stage. I'm not sure why the decision was made. Sometimes plaintiffs do a certain.
No, that's fair enough. And then Manuel, why isn't this different than Manuel? Because here your client was seized by an arrest in the first instance, whereas in Manuel, that question was reserved, and the court decided where the seizure took place in the first instance by judicial process. There's a footnote reserving just this case.
Yeah,
see, he knows
right,
it too.
I think in footnote 3,
that's right.
Manuel says that it's not going to decide precisely when legal process started, and we don't think the court should decide it here because respondent never raised the issue until its briefing to this court. And as I noted,
But would you agree he was seized by an arrest in the first instance?
He was seized by an arrest in the first instance and then seized pursuant to the initiation of legal process when the false criminal complaint was what held him over.
Well, a complaint can be filed whether or not someone is seized, right?
Oh my God. Oh my
You can
God.
file a complaint against a free person.
Right, I guess, Your Honor, what I'm saying is that for us to succeed on our Manuel claim, we're going to have to show that it was a seizure pursuant to legal process. We accept that. We, of course, also have, like I said, the Second Circuit's precedent that was also unchallenged.
And then the continuing seizure theory that we'd have to purchase if we're also buying the malicious prosecution tort of the Second Circuit.
Do you see his words that we'd have to buy, we'd have to purchase?
Your client was seized even when he was released on his own recognizance. And for the entire period until the completion of trial, is that right?
The Second Circuit precedent on that respondent never challenged says that the travel restrictions that automatically apply upon release, upon recognizance, and also consistent with Justice Ginsburg concurrence in Albright. Again, we don't think the court should get into any of this. It's a hard question.
Right, but if we buy malicious prosecution, if we endorse this tort part of it, at least in the Second Circuit and some others, is that you're seized even when you're released on your own recognizance, right?
Well, I don't mean to fight the premise, Your Honor, but I don't think the court has to buy into any of that.
Buy
The
it.
court
He finally said, I'm not
simply
selling anything.
accept, as respondents did throughout this entire proceeding,
Accept
that there
it.
was a cognizable seizure here, and the Second Circuit can decide whether respondent waived that argument or has stated something.
Your position is going to be that he was continually seized through trial, right?
Yes, we believe respondent forfeited.
Yes.
With respect to those seizures, he forfeited any challenge.
And just to finish up, on that theory, are people also seized even when they're given a citation but free to go, released on bail, who receive a civil process for a subpoena to appear at trial?
He was brilliant.
Are
This
those
lawyer is
persons
brilliant. He
seized?
killed him.
I think the reason the bounds of that rule hasn't been litigated in this case, and I can't answer your question, is that respondent never raised it below. And so we're proceeding under the unchallenged Second Circuit precedent. We, of course, also have the seizure
Listen to that.
undisputedly took place between the time that the criminal complaint was filed and that the hearing in this case took place.
Justice Kavanaugh?
Mr. Ali, the tort of unreasonable seizure pursuant to legal process, do you accept that that requires the plaintiff to prove the elements or some of the elements?
3726. We'll come right back to this spot. I want to show you guys something that is just so brilliant that lawyer does. Neil Gorsuch, he does everything he can to take him into some sort of hypothetical realm of reality that simply is false. And the lawyer just continues to just pull him right back to case law. And just so you know, I've never prepared for a Supreme Court case, but I would imagine what I imagine I do now. If you see on my tabs, those are all Supreme Court cases. I would just read all those cases. I would read every case. I would read the footnotes. I would know every bit of Manuel, every bit of McDonough. I would know every bit of those cases. The footnotes, I would know what each judge wrote. I would read those judges' opinions from their previous cases. So I understood the flavor of that court case so that like he does here. And every time Gorsuch tries to take him off track, and if you guys don't mind, we could just go back 1 minute and just listen to how brilliant this lawyer is. This lawyer he follows the law. The lawyer, so just so you know, all cases are based on case precedent. That's why I prefaced this when I started this talk, you remember? I said all cases based on case precedent. And so let's just go back 2 minutes to 35. 2 minutes just to listen to this back and forth between Gorsuch and the lawyer and watch the lawyer just push case law right back on him, even list the judge's opinion and who said it. And you notice how Gorsuch had done the same thing. He knew every bit of every case, the footnotes, everything, and he's pushing against it. He doesn't want you to be able to file for, and this guy filed for malicious prosecution from behind bars. That's pretty impressive.
Second Circuit's precedent that was also unchallenged.
And then the continuing seizure theory that we have to purchase, and we're also
That we'd have to purchase, he says.
Prosecution tort of the Second Circuit. The theory is, as I understand it, that your client was seized even when he was released on his own recognizance, and for the entire period until the completion of trial. Is that right?
The Second Circuit precedent on that respondent never challenged says that the travel restrictions that automatically apply upon release, upon recognizance, and also consistent with Justice Ginsburg concurrence in Albright. Again, we don't think the court should get into
Ginsburg's
any of the hard
concurrence.
But if we buy malicious prosecution, if we endorse
Buy.
this tort, part of it, at least in the Second Circuit and some others, is that you're seized even when you're released on your own recognizance, right?
Well, I don't mean to fight the premise, Your Honor, but I don't think the court has to buy into any of that. The court can simply
Accept the
as
case
respondents did
precedent.
throughout this entire proceeding, that there was a cognizable seizure here, and the Second Circuit can decide whether respondent waived that argument or has stated something.
Your position is going to be that he was continually seized through trial, right?
Yes.
Yes, we believe respondent forfeited, with respect to those seizures, he forfeited any challenge.
And just to finish up, on that theory, are people also seized even when they're given a citation but free to go, released on bail?
He'll take it anywhere he can.
Receive a civil process for a subpoena to appear at trial. Are those persons seized?
Your Honor, I think the reason the bounds of that rule hasn't been litigated in this case, and I can't answer your question, is that respondent never raised it below. And so we're
That's not the
proceeding
question.
under the unchallenged Second Circuit precedent. We, of course, also have the seizure that
Remember what he said earlier? That they had to write 50 pages They had to write 50 pages on what seizure meant in a previous case. So he's asking him, well, is he seized if he gets a citation but free to go, released on bail, but receive a civil process? That's what he's saying. A subpoena to appear, is the person seized? He's trying to get the lawyer to answer a question that he simply cannot answer in a paragraph. And so the lawyer says, Your Honor, I think the reason the bounds of that rule hasn't been litigated in this case, and I can't answer your question, is the respondent never raised it below, didn't ask that question. We're proceeding under the unchallenged Second Circuit precedent. This lawyer is brilliant, brilliant. I mean, his words are just, he sidesteps the entire thing by saying, I can't answer the question. But we're gonna go by the unchallenged Second Circuit precedent, which is on your trifold of Turner versus Driver. I don't think it's the Second Circuit, it's the Sixth Circuit, I believe.
Disputedly took place between the time that the criminal complaint was filed and that the hearing in this case took place.
Justice Kavanaugh?
Mr. Ali, the tort of unreasonable seizure pursuant to legal process, do you accept that that requires the plaintiff to prove the elements or some of the elements of malicious prosecution, including absence of probable cause?
So the Fourth Amendment, to prove his Fourth Amendment violation, yes, we agree that petitioner would have to prove the absence of probable cause, but it comes from the Fourth Amendment, not from any tort of malicious prosecution.
Okay, and then to follow up on answers you gave to the Chief Justice and Justice Breyer, just want to make sure I have this clear. Your answer to the floodgates argument on the other side is that there really won't be a floodgates problem if we don't stick with the Second Circuit and the other circuits rule because of two things. One, the absence of probable cause requirement, and two, qualified immunity. Is that accurate summary?
And also, as I discussed with Justice Alito, the causation requirement.
So for those of you guys who are trying to get rid of qualified immunity, this gets us one step closer to this holding right here.
Which actually does a lot of work in these multiple actor cases when you're suing a police officer. We also, just to be very clear, we think the favorable termination rule is not a filtering rule, and so we, like Chief Judge Pryor, find it hard to figure out how that even factors into this case.
Thank you.
Justice Barrett? Thank you, counsel.
Okay, this is the, that's going to be the, that is going to be the, let me just pop this off real quick, guys. That will be the defending for the state to try to make sure that they can keep malicious prosecutions and just arrest us out of our homes with no accountability. So I'm going to save that other half because it's an hour long. I'm going to save that. Sorry about that, guys. I'm going to save that other half for tomorrow. So I just want to reiterate a couple of questions for you guys, and then I got to get out of here because I've been on here for a long time and I got more work to do. So there's people that I have, just so you guys know, I have at least 36 people waiting for me to call them back for a place that apparently was so fraught with corruption that it goes everywhere. It goes everywhere. The whole town. So only the people are the victims now because now the state is prosecuting you for not having your driver's license. And so we are only this far away from changing that little space right there. And so, anybody from other corners of Ohio, if this is happening around you, I'm going to go up and down Ohio for the next 3 years before I run for governor there. And I'm going to run for governor in Ohio, and I'm going to win. Because the people are sick of this. So you guys need to infect the world. You need to tell the world that change is coming, that there's a new system called transparency that no longer has the words police or law enforcement in it. It's not there. We don't say those words. You say transparency is here, meaning that everybody can see everything now. And I can't wait to show this to you guys. I just have to get these civil rights lawsuits filed. Yunez, coming up for Yunez. Has everybody seen Yunez's video? If, can one of the moderators, I'll stay on long enough for you to post Yunez's video. Okay, my mic funny? Sorry about that. Can you, sorry about that, guys. So post Yunez's video because I'll be in Dallas next week for, to file Yunez's civil rights lawsuit. Sorry. Is that better? Can you guys just hear better like that? Is that better? Did that work? Because there's no noise in here, so it's just my iPhone. I just don't like, I mean, this thing's supposed to work good, but let me try it. Let me see if it works. There. Is that better? Did it fix or is it still? Oh, yeah? Did it work? Take it out? Is that what you said? Okay. I'll take it out. There you go. So, if you haven't seen that video, I really want you guys to see it. It's really, so let me know. And all right, cool. So the 5 charges, remember, if you've been charged with these 5 charges, obstruction of justice, tampering with evidence, trafficking drugs, and when you're just a user, fleeing police, or attacking police, those are the 5 charges. That's the reason why I'm showing you this video. That's called malicious prosecution. So you don't take a plea deal, you fight it, and then you can take them to court for malicious prosecution. That's why I showed you guys that. Because those are the 5 charges that they're charging felonies for, and then putting you in the rehabs that are owned by the judges and the families, like the slum lords there, which is just terrible, terrible, terrible. Okay. All right. Listen, X Factor, I look forward to reading your appeal. X Factor, can you please email me the appeal? I want to read that. Maybe I'll put X Factor's work up here. Okay. God bless you guys, man. Thank you so much for coming. I appreciate you coming. X Factor, I can't wait to read your brief, brother. I cannot wait to read your brief. Really can't wait. Super stoked about it, man. I can't wait to read it. If you can send that over, X Factor, then I'm going to read that. I won't put it on air tonight because I'm just too tired, but I'll put it on air tomorrow, and you guys can send me that, and I would love to show you some of X Factor's work. He's incredible at traffic tickets. He's incredible at getting traffic tickets removed. He's really good because it's all about jurisdiction, in case you guys didn't know, and then due process of law. So that's what X Factor is really good at. Do not overwhelm him. I still need him to work with me. So do not overwhelm the X Factor. All right, can't have that. But he's a great guy. So, all right, man. Listen, Pam, tomorrow you get sued. Tomorrow, Spoljaric, you get sued. So enjoy those federal civil rights lawsuits. Can't wait. All right. Thank you guys so much. God bless everybody here. Thank you guys for coming to this channel. I'm glad we learned together. I will get the flock out of here. I'm tired and I got to do more work. All right. So I'll see you guys next time. Remember, we don't stop. We don't stop. Make sure you guys hit your like button. I'm sorry, take your like button. Thank you. Take your like button. Take your finger where there's still 500 people here. Everybody, I know you were just listening, so take your finger and just hit your like button. Everybody just like this. Let's see if I can get, just hit it. Just take your finger and just hit your like button. Just do it. Just take your finger. They're not even looking. They're off going to the bathroom, doing their hair. All right, listen, thank you guys so much. And I'm super, super grateful that we got to do this tonight. And tomorrow we will go over part 2. You will listen to the state's argument as to why malicious prosecution should be abolished, why you shouldn't be able to prosecute. We've already given legislators, judges, prosecutors prosecutors and cops qualified immunity. Maybe we should just give prosecution of you immunity as well. That'd be the next step. All right, I will get the fuck out of here later. We don't stop. We don't stop. We don't stop.